what we've done to create a modern legal education is to make each year different. The first year should be much more foundational, much more basic. The second year, more detailed, somewhat like all 3 years are now. And by the third year, the students are ready for an interactive experience, something that engages them in taking initiative and doing the kinds of things that they will be doing in a few months once they go into practice. So the idea of the first year is some very basic foundational courses, a general introduction to law during the first week, almost part of an orientation, that tells all of them just what a court is, what a case is, what a statute is. Then more foundational courses, courses that don't necessarily give the students as much detail, but gives them a context and a grounding across the entire range of law. So they should have a course on regulatory law. They should have a transactional course where they actually look at contracts or look at deals. And then they should have litigation-oriented courses where they learn about modern litigation, learn how to read cases, and learn how to apply them. With the second year, they can then pursue subjects in more detail. And based on the subjects they pursue, they can then engage in more interactive and detailed work in the third year. So what we have is at the end of the first year, they can, if they choose, they don't have to, but they can, if they choose, select a concentration. And that involves taking a menu of courses in the second year and getting themselves to a level where they can then do more sophisticated or interactive work in the third year. And that can either be real research, or it can be a placement out in the outside world, or it can be something else that engages them as active learners, because by that point, by the third year of their professional studies, that's what they're ready to do. So in other words, the idea is to rethink legal education for the 21st century so that it reflects our modern thinking about law, the content of law in the 21st century, and our modern thinking about how people learn. Another problem for legal education has been the integration of clinical legal education with the traditional classroom approach. Clinical education came in much later, in the middle of the 20th century for the most part, and it came in response to the obvious gaps in the traditional program. Among these are that the traditional program doesn't teach students how to interact with clients. It doesn't teach them counseling. It doesn't teach them interviewing. It doesn't teach them any of the human skills that are so important to the practice of law. And of course, a parallel development occurred in medical schools. The problem in law was that the Langdellian curriculum was so crisply conceived that it had a kind of an impermeable boundary around it and was very hard to penetrate. The result is that clinical legal education was an add-on. It simply exists apart from the traditional program. Very often it's delivered by professors who are not tenured and are not regarded as members of the same professoriate as the people teaching the traditional courses, and it's done in separate courses that are basically unrelated and very often unconnected to the classroom experiences. So one of the things that we've done here is to try to integrate those two by creating these concentration programs and having the faculty of the concentration program consist of both traditional classroom teachers and clinicians. So the idea is to build experiential components directly into the education. Here's one example. In the international program, what students do is attend, in addition to learning basic subjects like international law, international business transactions, international human rights, a international law laboratory where they're trained specifically in those counseling and interactive skills. They then go off for a semester and do an externship, which is supervised. But the externship specifically builds on what they've been trained to do in the international law laboratory. There are enormous other possibilities here. If you have a regulatory program, for example, you can build directly into that a legislation laboratory where students help the state legislature which are always woefully understaffed, actually draft legislation, or a city legislature, a city board of supervisors, or city council, which are even more understaffed and are often very anxious to get help from intelligent, assiduous law students. You can build traditional live client clinics directly into a litigation program. You can build somewhat different transactionally oriented clinics into a business program, and so on and so forth. But the idea is to integrate this clinical education, now thought of as experiential learning, into the same program that is delivering the traditional courses, rather than ghettoizing it as a separate area with a separate faculty and a separate set of courses. And this is really important because the kinds of experiences that we now label clinical and that I would label experiential are the ones where you teach law students all the things that are so essential to the practice of law and aren't embodied in any kind of doctrine or classroom experience, such as how to relate to the client, how to judge whether the client is telling you the truth or not, how to ask questions and get what you need to know from the client without scaring them off, how to reassure clients, how to give them bad news when bad news has to be given, and a whole variety of other skills that are, as every practicing lawyer knows, are absolutely essential to the successful practice of law.